All right, everyone, we're going to get started, and we will have a couple of representatives of Lummi Nation joining us shortly. They're on their way. But we'll go ahead and start things off. I'd like to begin. Again, my name is John Tuxell, and I teach here at Fairhaven College. I'd like to begin with a land acknowledgement. Western Washington University's main campus, where we are today, is situated on the ancestral homelands of the Coast Salish peoples, who have lived in the Salish Sea Basin all throughout the San Juan Islands and the North Cascades watersheds from time immemorial. We expressed our deepest respect and gratitude to our Indigenous neighbors for their enduring care and protection of our shared lands and waterways. I'd like to acknowledge the co-sponsors for today's talk. They include the Foundation for Western and Alumni, the WWU Tribal Relations Office, the Native American Student Union at WWU, the Center for Law, Diversity, and Justice here at Fairhaven College, the Center for Canadian American Studies, the WWU Border Policy Research Institute, and the Ray Walpole Institute. We may have set a record for the most co-sponsors this week. I'm delighted to introduce John Gailus, our first speaker. John's going to start things off, and then we will be hearing from folks from Lummi as well shortly. John is a founder and director of Cascadia Legal, LLP in Victoria, BC. Mr. Gailus is a member of the Cumshewa Clan of the Haida Nation. He has a varied law practice focused on consultation, Aboriginal and treaty rights litigation, Indian Act issues, and economic development, both on and off reserve. John has served as counsel in all levels of court, including the Supreme Court of Canada on multiple occasions. He is also an adjunct professor in the University of Victoria Faculty of Law, where he teaches the Indigenous Lands, Rights, and Governance course. Please join me in welcoming John Gailus.
I want to thank WWU and World Issues Forum for inviting me here today to speak on this. The plan was for Julius to give you a little bit of background and Lummi perspective, but I've kind of got the presentation. There's a place where I can stop and let Jay have his speech, and then we'll talk about the legal stuff, which is really boring. So I teach the Indigenous Lands, Rights, and Governance course at UVic. We call it, really what it is the Aboriginal law course. We don't really spend a lot of time talking about Indigenous law. And that usually takes a semester to go through it. But I thought it might be worthwhile to give you guys a 10-minute overview of the Canadian law around Aboriginal rights and Aboriginal title. And the starting point is Section 35 of the Constitution Act, 1982. So that provides the existing Aboriginal and treaty rights of the Aboriginal peoples of Canada are hereby recognized and affirmed. Now, it wasn't until 1990 that the courts actually explained what that means in a case called R.V. Sparrow. Actually, might be worthwhile putting up our map now, our Google map. I like maps. And what Sparrow confirmed is that Section 35 actually has some meaning. It's not just simply, in this case, the Crown was saying preambular, which essentially means that it's more of a political statement than that there are actual rights embedded in Section 35. Because the plan was that there were going to be what were called these constitutional conferences, where the governments of Canada, the provinces, the territories, and Indigenous leaders would sit down and figure out what these rights are. But there were a couple conferences, they were unsuccessful, and eventually those sections of our Constitution actually got repealed. So it's been up to the courts to try and figure out, what does this mean? What do when we're talking about existing rights recognized and affirmed? And so Sparrow involved a man who was fishing on Canoe Pass. You'll see on the map here, this is Delta Richmond. The south arm of the Fraser River comes in between there. And Mr. Sparrow was from Musqueam, which is their reserve is right across from the airport in Vancouver. So quite close. No, thank you very much. Canoe pass, you see Westham Island right there. He's fishing. He's actually a commercial fisher who's fishing for his people from Musqueam, catching their food fish. So when we're talking about BC in particular, one of the problems that we have is we don't have treaties for the most part. So there's Treaty 8, which is up in northeast of British Columbia. There's a few treaties on Vancouver Island called the Douglas Treaties. And then there's a modern day treaty at Tsawwassen right here. Some of you might be familiar with this geography. There you see the ferry terminal and then Roberts Bank Terminal 2 there, which I'll get to. So what's been going on is we've had a treaty process that's been going on for 35 years. Very few treaties have been settled. There's been quite a bit of litigation ongoing, but it's not like development stops. So Canada, British Columbia, who have divided authorities, so it's a little bit different in terms of decision-making, perhaps, than in Washington State. So, things like ports and massive industrial developments, sometimes Canada makes the decision, sometimes British Columbia makes the decision, sometimes they both have to make a decision as to whether or not to approve the project, which is what happened with Roberts Bank Terminal 2. So it wasn't until 2004 that the Supreme Court of Canada confirmed the Crown, we call it the Crown because we are still a constitutional monarchy. King Charles is our king. The Crown has a duty to consult in certain circumstances. So before they're going to approve a project, say like Roberts Bank Terminal 2, they've actually got to talk to the First Nations that might be affected by it and see if they can come to some sort of accommodation. Figure out a way that the continued exercise of Aboriginal rights can coexist with, the approval of a development. And the court set out a test in that case. It's the duty is triggered when the Crown has knowledge of the potential existence of an Aboriginal right and title and contemplates conduct that might adversely affect it. Now, not everybody gets the same consultation. For instance, in some cases we have nations that have established rights, like Musqueam in terms of sparrow and the right to fish for food, social, and ceremonial purposes. And other times we have nations that are engaged in the treaty process or have litigation that they've started to prove their rights in court. And so the court said, well, there's a bit of a sliding scale. It says the duty to consult is a procedural duty. Its scope is proportionate to the strength of claim and the seriousness of potential adverse effects. Now, the court says it's on a spectrum. I look at it more in terms of quadrants. Strong claim, adverse effects, you get what's called deep consultation. It's not quite free, prior, informed consent in terms of the UN Declaration on the Rights of Indigenous People, but there's an obligation there to try and find some sort of consensus out of it. And until we had a case that I'm going to talk about, Des Sautel, there was no duty to consult US-based tribes. So a lot of projects were being approved that would impact on Lummi's rights in particular in this area here without any consultation. So it wasn't until Des Sautel that Lummi had this procedural right afforded to it. I think I'm just going to cover Des Sautel, and I might turn it over to Councillor Julius to give some comments in terms of Lummi perspective, because I think that gets us to where we're at now. So, really straightforward case in some ways, really complicated in other cases. So Rick Des Sautel, he's a member of the Colville tribe, sort of in eastern Washington. He comes up to British Columbia, he shoots an elk, and he turns himself into the conservation officers. He gets charged because he's not a citizen, he's not a resident of British Columbia. He gets charged under the Wildlife Act with hunting without a license. His defense was that he has an Aboriginal right. He says, I am an Aboriginal peoples, I know that's not grammatically correct, of Canada, and therefore I have an Aboriginal right to hunt, which has never been surrendered. There's never been a treaty entered into me that extinguished that right. And so it goes through several levels of court. And the Supreme Court of Canada has this question they need to answer. Is the meaning of Aboriginal Peoples of Canada in terms of Section 35? Does it mean Aboriginal peoples resident in Canada? And the court says no, actually. In Mr. Desautels' case, and also opens up the possibility of other US-based tribes, Aboriginal Peoples of Canada means the modern-day successors of Indigenous peoples who occupied what's now Canada at the time of European contact, even if those people now live outside of Canada. So we've got a good example. If we go back to West Coast on our Google map, and this is the only time I will quote your president. He said, well, somebody just took a ruler out and drew a line across the map to establish the 49th parallel. And that's exactly what they did. Because you'll see Point Roberts is part of the US. So rather than actually tracking the geography, Point Roberts is taken out. This line, sort of the squiggly line here, when in 1846, when the Oregon Boundary Treaty was concluded, Great Britain was of the view that this line should go further to the east, in fact, through Rosario Strait. The US took the position that it goes through Haro Strait, and it actually went to arbitration. And Kaiser Wilhelm, the Emperor of Germany, decided that the Americans were correct. And so now we have the border running through the Canal de Haro, or what Spanish called the Canal de Haro, Haro Strait. So, but for that arbitration, the San Juans would have been part of Canada. So key dates, 1846, right, for claims of Aboriginal title. That's the date on which the Crown acquired, asserted sovereignty, because we've now got a border in place, which we didn't before. There was a treaty of joint occupation prior to this. Some of you probably learned this in history class. And then for rights, and these are the key dates in Canadian law. So if you're making a claim for Aboriginal rights, it's actually the date of first contact. So here on the West Coast, we're looking at 1791 to 1793, when the Spanish and the English are exploring. And why those dates matter is, going back to the finding in Desautels, modern day successors of those who occupied the Canada at the time of contact or the date of sovereignty. In terms of the work that we're doing with Lummi, it's around this procedural right, consultation. And the court doesn't give us a lot of help in this case. They only spend 5 paragraphs on the duty to consult. But they say, obviously, there's no duty on the Crown to seek out US-based tribes. The duty's on them to put the Crown on notice to say, look, we've got rights. They're going to be affected by this. We meet the test in Desautels. And that's sort of after that case came out in April of 2021. That's been the work that we've been doing, trying to get the governments of Canada and British Columbia to consult with Lummi. So I'm going to talk a little bit about the court cases that we're working on, but might be a good time to turn it over to Councillor Julius, if he feels up to it, to speak a little bit about the Lummi perspective.
Thank you. Thank you. And Aitzquile. Good afternoon, everybody. Thank you for having me. Thank you for the invite. Quatashlam Sunisnat. Aitzquile. It's good to be here. My traditional name is Potashlam, and my American government name is Julius, and it's great to be here with you. I am a citizen of the Lummi Nation. And this here, I'm not going to speak to the legal part of it, but I think going back to the first legal document that the immigrant sovereign United States entered into with the true sovereigns of this territory to enter into a peace treaty together was the 1855 Point Elliott Treaty. And this was a necessary legal avenue that had to take place if war didn't take place, to make it legal for citizens 6 generations ago to occupy this place. So for me, myself, Watathlam is my name. And I think you've studied a little bit about Bernard Stern. He tells the story of Skalaks and Watathlam and how Lummi ended up here. I like to call this place my federal prison. After the legal document that was entered into, we got placed on a 12,000 acre federal prison. And we had to evacuate the places we were autochthonous from, we grew from, we had been since the beginning of time. And I think there's a perception in this country that most Indians are all the same, even with Lummi, that all Lummis are the same. But when you go back to that moment in 1855 where we entered into that treaty with the immigrant United States, here, I like this aerial. It's great. And if it slid over and, you know, the corner was right here and went up, nope, other way. Now go the other way. Nope, other way. Yep, perfect. Now go down, bring the aisle. There you go. There's one thing in common here that makes Lummi, Saanich, Suk, Songhees, Semiahmoo very distinct from everyone else in the United States, and that's language. Language. And in terms of treaty tribes and those that signed, it's very unique here and distinct. Everything you see, or the majority of what you see here, Semiahmoo, Saanich, Lummi, Swala, Clactamish. But what's interesting about 1855 that most don't know is the 14 Lummi chiefs. Who were they? Did they come from this reservation and paddle to Mukilteo in 1855 on that January day? No. They represented different places. My grandmother's Vila Jefferson. My father's mother is Vila Jefferson. Her father was Simon. His father was Thomas Jefferson too. His mother was Victoria. Victoria's father was Chief Thomas Jefferson, one of the 14. And his real name was Willaluk. But what the United States did to identify these key figures of Lummi is with name, they used oftentimes presidential names. So for me, when I go home to the islands, I think about my great-great-great-great-grandfather, Thomas, when I'm here at Lopez, Shaw, and South San Juan. Because those are the reef net locations, the inherent intellectual, the inherent rights to this particular property that we now call UNA, or usual and accustomed. 1855 usual and accustomed for us points to place that couldn't be stolen, couldn't be sold, only passed down through lineage. So I think about that when I'm here. I think about, they called another Lummi chief, Chief Washington, George Washington. His name was Cumshewa. He had a couple of different names, actually. Dana, what was his other name? Chilaic. he was the chief of the, documented by George Gibbs, Stevens's kind of right-hand man, ethnologist, as the chief of the North. So he represented the Northern Lummi, per Gibbs. But my point is this, and then when you get up to Point Roberts, you look at the 1894, 1895 Alaska Packers case. One of the, is that the first case we brought forward post-treaty
Yeah.
in terms of legal, 1894, 95, and it had to do with Point Roberts. In the Alaska Packers case, there for me, my father's father was Haynes Julius. His father was John Julius. John married Catherine Jack in 1901. So my great-great-great-grandfather's Captain Yakship Jack, who, testifies and talks about the challenges and his inherent right to reef net locations at Cheltenham, Point Roberts. And a lot ties back to Point Roberts because this, you can see the dark spot off of what might be called Lily Point. Lummi protected that under a tribal cultural property or eligible for the National Register in 1994. It's a restricted document, but it protected the desecration of a cemetery, a massive cemetery, and but more important, the giant village site. That dates back, I believe it's over 8,000 years. It might be 12,000, but 8,000. Anyway, there's dark blue off of that point, and that's the reef. Yeah, see this here. And this would have been, when the newcomers arrived here, you can scroll up even more water, show more water. Yeah, keep going. Yeah, this right here is, if you know how salmon operate, they go home on the flood tide. And reef nets are typically designed for the flood tide when they race out of these bays, but they'll mill around in these different pockets of bays when they come in from the ocean through Juan de Fuca Strait. Lummi's a saltwater people. It wasn't until Huitlatlam was murdered by his Scalachan wife's siblings here on what you now know as Lummi. This is 1600s, 1700s, that his brother Scalaxt got revenge. And this became the most recent expanded territory of the Tlactamish, the Lummi. Prior to that, you would see us here, up there, over here, which you now know as Canada. Not a river people, but reef net technology ties and tells a lot of that story. But the 14 chiefs paddled from different village locations. Our creation story goes to North San Juan by Roach Harbor. It's called Garrison Bay, village called Papiawith. And our first man was blown into existence by Howells, the changer. And that's our creation story, creating the first man named Switan. And then so that was the first Lummi village, was right here on San Juan Island. And then second was a place called Alalong, which is Orcas Island, West Sound, place of many houses. And, those are two really important because for me, my bloodlines go here because my great-great-great-great-grandmother was Pachasia, sister to Chief Washington on my mother's side. And one of her children, Mary, married Joseph Solomon, whose father was Chuskin, another prominent reef net and what you would call a chief. So the connections for me as an individual in my bloodline are really deep spiritually to each of the islands because of my connections through bloodline. It's different. It's hard to put into English words what's felt. So they're all significant to me. It's not one place. in terms of what's worth protecting, what's worth putting everything on the line and fighting to protect from development of things that aren't in line in character of who we are. For me personally, it's all of them. And there's no compromise. So for me, I think that's really important for us in Lummi and those who are studying Lummi to understand that each chief came from and represented a place and paddled from here to Mukilteo to enter into this legal agreement with the immigrant United States at that time in 1855. And to really put it into perspective, you really think about that, and I've shared this here several times, is you're looking at someone right now who is one of the last touched, the last met, one hug away from pre-contact. I was raised by Quatashlam, who was born in 1888, and Snina, who was born in 1891. I'm 50 years old now, but I was brought up by them, and they were raised by pre-contact individuals. So it really puts it into perspective that these timelines that we think about today in modern time, it's more than that. It's 17 decades. I've been here 5. It's only 17 decades ago that this took place, which is not very long. It's really new. So, and a lot has changed. And this is why I'm here with you, because what we see as normal here and in this country, for us being the last touched, this is all new. It's not a political position on things. It's we want to hold on to what once was, this Eden, this relationship-based living. That's not something we need to teach our children. It's a way of life that we grew up in. That we're not supreme, we're less than. Everything, we believe in creation, in our creation story, and we're brought up that way, that everything is alive. Everything is alive. The rocks, the water, the salmon, and we use the word save. How do we save them? But it's really not them that need saving. It's our philosophies that got us to where we are, that are creating the devastating destruction of everything that once was. So that relationship-based living is something I grew up with, and I'm here because for many reasons, but I think that examining our philosophies that got us here and the norms that are going to get us to tomorrow, taking a look at, because we're in a unique situation right now in this moment in time, and it may not be super important to everybody, but we're witnessing the extinction, the massive extinction of things that existed long before us, that call this home, that we're guests of. The rivers, the salmon, the orca, that's real right now, and it's, if we have a relationship and understanding the way my grandparents did, then there'll be some urgency to examine our philosophies and how do we live together? How do we value the invitation to be one with this place and coexist together? And yeah, so I just wanted to share that, and I don't want to take up too much of your time, but the visual that my grandfather always shared in his home, who helped raise me, was that visual when I was a little kid of our canoes being shackled together and us having to leave our different villages and go to this federal prison called the Lummi Reservation. And where we originated from is not just this little reservation. We are autochthonous to these places, individual families, and we come from ReefNet technology, which is just an incredible technology for harvesting salmon and taking care of a community, a whole community, a whole village. So I think, is there anything else, Dana, or you guys want me to share? Or if not, I will
Keep going.
turn it over to you. Well, I think one thing that's important to me is, if I'm going to keep going, one thing that's really important is we were a very strong people. There's often a perception that we weren't warriors. We're just fishers and hunters and gatherers, but we protected and we defended, and we did it well. We were front line here to many different situations. But one thing I think that's important for all of us to understand is we were a compassionate people when the newcomers arrived. We're a very compassionate people. And I think we're in a time right now where we see a lot where there's lack of compassion. And when the immigrant was here in 1855, that's who we were. That's what we were. And I think as we learn more about this place and how welcoming it was in the 1850s at the arrival of the newcomers, and how we are today. And to me, the treaty is a forced marriage, and it's been an abusive marriage for about 170 years. How do we shift that? How do we acknowledge that abusive relationship that we can't really break free of? Neither can the orca or the salmon or the rivers or the Salish Sea and everything that comes with the agreement with the Lummi, because they're all part of it. You can see it in our court cases. Our Supreme Court cases all involve salmon. Everything. The last one decision came out in 2019, and it was culverts, but it's all around salmon. Protecting the existence of everything that was here before us. But Dana, anything? Councilman? No? Well, thank you. And I think you're going to open it up for questions later.
Yeah.
And I'll stick around.
Yeah, I've got a few more things to talk about the court cases. So
Aishka. Aishka.
I think it's very important to acknowledge that in terms of the challenges that Lummi is bringing forth, it's not about looking for economic benefits. It really is about protecting the environment and your way of life. I'm probably going to mispronounce it, Chilangan. I hear that a lot. So, we see this line here in terms of the international boundary. The facts on the ground are post-Bolt decision. That's all Lummi's UNA, as they say. They've got established treaty rights in that area, and not just domestic or sustenance rights, right? There's actually commercial rights that attach to that as well. And so when we're talking to Canada or British Columbia, we're saying, well, there's established rights up to that line. It's not a line Lummi agreed to. And, we go back to one of the findings of fact from the Bolt decision. You guys have probably heard this before, which talks about the usual and accustomed fishing places at treaty times included the marine areas of northern Puget Sound from the Fraser River south to the present environs of Seattle and particularly Bellingham Bay. Freshwater fisheries included the river drainage systems, especially the Nooksack, emptying into the bays from Boundary Bay south to Fidalgo Bay. So there's two geographic references there to Canada. Boundary Bay used to be known as Semiahmoo Bay, and the Fraser River. And the geography of Delta has changed radically with diking. In fact, there was Point Roberts. And when we talk about Point Roberts, we're not talking about that tiny little town where Canadians go down to get cheap gas and cheese. It's actually there's a peninsula there. The Spanish called it Isla Zapata. It looked to them like an island because all of this, and there's a reason why it's called Delta. It's the Fraser River Delta. And so you had Point Roberts, and then you have to go all the way up to Point Grey in Vancouver. So if we just go down a bit in terms of points of land. So University Endowment Lands, that's Point Grey there. All of this is below sea level. Like the Fraser is just running all over the place in terms of little fingers and everything. Richmond is below sea level. So this is where, and Jay mentioned it. We've got Saanich, we've got Lummi, harvesting fish, living part of the year here. The border is irrelevant. The reef net sites may well be in the United States now, but where the fish are getting cleaned, dried, drying racks, they're not commuting back to Lummi. And it was a massive fishery. They're selling it, and that was the whole point of Alaska Packers. Was Alaska Packers comes in and installs these fish traps, and they stole your reef net sites. But even in spite of that, you still continue to have a very successful harvest in other spots. So it wasn't just, well, we're just fishing here in the U.S. Like it's a full-on society. There's hunting, there's fishing, there's gathering, there's dealing with the trees there, cedar, creating baskets. Constructing houses. And so that's the pitch that's being made to Canada and BC is, from Lummi's perspective, it's like, hey, we were there. The archaeology supports it. There's 2 archaeological sites. There's one place called Wayland Farm, which is right on the line. And then there's another one at Beach Grove, just up there where there's a really nice golf course. Massive mounds. Massive mounds. So, going back to Des Sautel, right? Are you the modern day successor? Well, the interesting thing is that in the early explorers records, particularly the British, Captain George Vancouver, and the folks on his ship, identify Lummi by name. So we don't even have to establish that because in a lot of circumstances, you might have, in Canada in particular, you might have a band. So there's 200 plus bands that have been just basically divided up by administrative convenience by the government of Canada. They may not be in the historical records. You might have to trace them back. And that was the issue that Des Sautel faced was there's a group called the Cynics. And they were trying to figure out in that case, well, who is the rights holder? Who was around at the time of contact? Is it the Cynics? Is it Colville? Is it this band called the Arrow Lakes Band? And these are the things that we don't have to face here because Lummi is Lummi. And Lummi's always been Lummi. So, as I said, in terms of Des Sautel, the pitch to the governments was, we have rights. They've never been extinguished. We want to exercise our rights in Canada again. Canada says, well, you haven't been exercising rights, so therefore you must have lost them. It's like, well, the assumption was that border was a hard line, that effectively it operated to extinguish the rights, both the substantive rights and the procedural rights. And the Supreme Court of Canada said, no, that's not the case. And it works both ways. I mentioned, San Juan Islands, for instance. Saanich came down there as well, right? And so they lost access to that. So these consultations often take place in environmental assessments. As I said, Canada and BC have divided responsibilities. Sometimes Canada takes the lead, sometimes BC takes the lead. Most of the time, BC takes the lead. So there's a project that's being planned here. There's the ferry terminal, and this is Roberts Bank Terminal 2. It's 1 mile from the border. 1 mile from where Lummi has established rights. Lummi says, well, we're asserting we have Aboriginal rights beyond that, in the Canadian sense, to fish, to harvest. Canada basically ignored them. They ran out the clock on Lummi. They approved the project. Well, they approved the environmental assessment. The project still needs to go through a few steps, and ultimately the proponent, which is a Crown corporation, so it's a corporation owned by Government of Canada, has to decide that they want to build it. So we took that to federal court, and we got a decision after about 18 months from the federal court judge. Bit of a mixed bag. She found that Lummi had actually set out a strong claim to consultation, that they were entitled to what we call the mid-range, but inexplicably found that the duty had been met in that case. Even though Canada said in their advice to the ministers, we're not consulting. But somehow the court came to the conclusion that what they did met that standard. So that's under appeal. So I sort of said to Gabe, the attorney, it's kind of like a three-legged stool. We got 2 legs, but we need all 3 to be successful. So Canada is basically, and even in the more recent correspondence, they're like, well, we're not sure. We're going to continue talking to you, but we're not formally consulting. There's a bunch of other projects. So just to the east of the existing terminal at GCT Deltaport, there's another project, which is Deltaport 4, which is going through the provincial process. So potentially you could have a massive extension coming out this way, and then another one this way in terms of container traffic is what they're looking at. I'm sure people are familiar with the Trans Mountain Pipeline, TMX, and the increase in marine shipping that's going to bring. This would also be a massive increase in terms of container ships, if either one is built, let alone both. So that one's going through a provincial process. If we just zoom out a little bit, we've got, you see the Fraser River Tunnel project. Any of you have ever driven up to Vancouver, you go through the Massey Tunnel. There's a plan to replace that, to double its capacity. That's going through an environmental assessment. And a little bit further down, Tilbury, there's a Tilbury LNG project when you're going down the Fraser. And a couple other projects. They're a little bit further down there. Anyway, so Lummi has requested to be consulted on those projects. The actual submission that we put into Canada on RBT2, we'll call it, Roberts Bank Terminal 2, was not as extensive as what we put into BC. And in fact, I think, having worked in this area, I think there's enough there for a civil claim. So BC said, well, we've got this process under our act. It's called Participating Indigenous Nation Status. And it's section 14.2 of the act. And it's a pretty low threshold that gets you in. And if you get in, you get all of these opportunities. It's not quite free prior informed consent, but it's a hell of a lot better than duty of consultation. So the nation applies, and then the chief executive officer of the Environmental Assessment Agency says, you're in unless you determine there's no reasonable possibility the Indigenous nation or its rights recognized and affirmed by Section 35 will be adversely affected by the project. So it's very, very low threshold. So BC decided in June of 2024, essentially they'd have to let Lummi in. given this threshold. But they found a workaround. And there's an obscure act that they relied upon to pass what's called an order in council. Think of it as like an executive order from the desk of the president. I said I'd only mention them once. Sorry, that's twice. Saying, you're not eligible to be a participating Indigenous nation on these 6 projects. They did something similar for Alaska tribes, who are also wanting to be consulted, so the ones in the Panhandle, who I also represent, and also the cynics, so the group that was actually in the Dace Hotel case. And so they passed a series of these orders in council saying, nope, we're not going to give you PIN status, but don't worry, you'll still be consulted in accordance with Haida and Dace Hotel. And that hasn't come about. So we took a judicial review of that decision. We were waiting to hear from the federal court on the other one. But finally, it got to a point where we had to bring a judicial review of the order in council. And it's kind of a 3-pronged challenge. It's essentially, we were saying that the order is, do we have any law students in here? Or wannabes? Latin, ultravirus. Ultravirus is the term, which means you didn't have the authority to pass this order. So that's one prong. But also that it's inconsistent with certain commitments that the government has made to incorporate the UN Declaration on the Rights of Indigenous People. They passed a law. They were the first jurisdiction in North America to do it. And obviously not consistent with that. And the second one was an administrative ground, which is called legitimate expectations, which means if you agree to following a certain process as a decision maker, you're obligated to follow that process. So what happened here is we're waiting for our decision that we're in, and the government, the cabinet, so these are the premier and the cabinet, put their thumbs on the scale and say, no, you're not eligible. So, so that case has been filed. We're dealing with the province on that. But last week, we got a letter. All of the 3 US-based tribes got letters saying, and all of the 3 US-based tribes have challenged that order in council. And none of those have been heard. So the province said, well, we're actually going to amend the act itself. So again, useful analogy, executive order versus act of Congress. A little bit harder to challenge because the executive order, the order in council is really a regulation, and you can challenge on that basis. So basically a way to try and thwart Lummi Alaska Synext again from even having these issues heard. So we got to respond to that. Just a little more context, though, in terms of what's going on in British Columbia right now, is the government has completely mismanaged the Indigenous file. You've probably heard that there is a decision that came from the Supreme Court of BC in August last year involving some lands in Richmond here. This is South Arm. I'm not sure exactly where it is, where the Cowichan Nation had established Aboriginal title to a portion of that. And of course, all the landowners are freaking out that they're going to lose their homes. And the government is appealing that decision. Actually, everybody's appealing that decision. Saying, well, we're going to legislate on this, or we're going to guarantee everybody's mortgages, which is crazy because Cowichan's not going after anybody. But this is a function of, government not negotiating treaties. So, BC, when they entered Confederation, said, no such thing as Aboriginal title. We'll just take it, which is what they did. They've done. They just take it. Adverse possession. We'll squat, and they'll force them to kick us out. So that's one thing that's going on. There's another decision called Gitsala from the BC Court of Appeal involving the Mineral Tenure Act. And so there was a question in that case as to whether or not the Mineral Tenure Act was consistent with the UN Declaration. And the court said no. It's not consistent. And of course, everybody freaks out about that. And the government's like, well, no, courts, that wasn't your role. We've got this plan. We're going to work with First Nations to get our laws into alignment with UNDRIP. Now, there's no timeline on it. They could sit on it for 20 years if they wanted to. So BC is saying, well, we're actually going to amend the act there. So it's of a piece. You know, we were going to knock out the US tribes in terms of their rights. We're going to knock UNDRIP down in terms of keeping it out of the courts. And we're going to legislate to try and protect all of the titles that we've granted that are essentially void in law. So I think I'll end it there. I think we're available. We've got a little question period.
Yeah.
About 20 minutes.
Take questions.
Just direct
from
them
the
at
audience
Jay.
for Mr. Julius and for John. So first question.
You can probably take that down.
Hi, thanks for coming. I'm the director of the Border Policy Research Institute. We were really happy to co-sponsor this event. And I just wanted to make sure I understood you correctly with the Roberts Bank terminal case. It has been decided, but it's been appealed. And the decision wasn't about whether or not Lummi had a right. It was that the government didn't actually need to do a certain level of consultation with them. Is that correct?
Yeah, so that case and the other case as well is about procedure, process. But in order for Lummi to get its foot in the door, to get a seat at the table, they had to put forward what we call a strong, here's some more Latin for you, prima facie case, that they had rights in Canada. And so we went through that process. And so when you're determining the consultation, basically we had to fight everything in that case. Canada's lawyers and VFPR were saying, well, there is no duty of consultation. You actually have to prove on the Des Sautel threshold that you are an Aboriginal people of Canada. So essentially saying, you got to go to court to prove this, which is directly contrary to what Haida says, right? You deal with the assertions, you say, okay, how strong is your claim? And I mean, there's no doubt that the impacts are massive. So we were saying, we got a strong claim, adverse impacts have already been acknowledged. We need this deep consultation. And so we were successful on like I say, on the two grounds, but the judge, and this happens oftentimes in court cases, is the judge will come to a certain conclusion and then try and reverse engineer it later, because there is a fair amount of deference. We see this here in US cases as well, that's owed to, in this case, the federal cabinet. The federal cabinet is making a decision versus the district manager of forest. Those are easy to knock out. It's the cabinet decisions. And so, I mean, that's the same battle that we're facing with BC. Did that get it? Yeah, so she wasn't going to overturn the order in council, which would mean the approvals fall and you got to start over with Lummi, not with everybody, or go back to a certain point in time. And that's what happened with Trans Mountain. Was the Federal Court of Appeal overturned it the first time, and they said go back and do it right, and then the nations challenged again, and the court said, okay, well, that's good enough. We'll let it go forward. So yeah, the appeal is focused on this whole issue around the adequacy of the consultation. And as I said, Canada never admitted they were consulting at all. So it's hard to square that with the judge's reasoning.
We have a question from a student.
Former student. Yeah, recent student. John, thank you for your time. Jay, it's always an honor to listen to you. Perspective shifting. I make my money in the San Juan Islands guiding, and so hearing you talk about your homelands is an honor. I have a specific question in regards to the expansion of the Roberts Bank terminal on your way of life, fishing. I know that the majority of that traffic comes down the Haro Strait, but what's the concern for you and your community in regards to this expansion?
Well, vessel traffic is definitely one of them. I think it's a lot of things that have led up to today. I think we've been on the menu for a long, many decades, and it's just recently that we're able to be at the table to have these discussions. And with Canada in this particular case, we're still faced with this challenge, but it's a lot. It's a lot in the last 17 decades that have led up to here. But vessel traffic, for sure. When something happens, we're in a toilet bowl. I don't like to get into the science and into the stuff that ISTs specialize in. But we need ISTs, so keep going to school and become an IST of some sort. We have a lot of ISTs on staff at Lummi, and they're extremely important. But the science behind it all, the common sense tells us where we've gotten to right now without a catastrophic spill, without a catastrophic that kind of shuts everything down. The accumulative impacts from what, in our case, the Army Corps of Engineers has allowed to go through, whether it's 23% of our ability to access usual and efficient and accustomed fishing areas and grounds within the San Juan Islands, Cheltenham, Bellingham Bay, Lummi's UNA. That's a cumulative impacts through our trustee. The Army Corps is our trustee. They're obligated and responsible to protect us. But it's through these federal processes, state processes, permitting processes that they make a decision that is perceived to be best for our interest and not too detrimental. But a lot has added up to where we are today in the last 17 decades. But realistically, it's a lot less than 17 decades since mass development. I mean, the refineries were installed when? Tawasin was installed when? We scratch our heads and we try to figure out where the problem is that caused this to happen with the salmon population, with the depletion of crab, with the starfish disappearing, with all of this. And we're trying to identify it through science, but what about common sense? And common sense tells me that with Roberts Bank having to dredge 280 football fields worth of toxic silt, and again, I'm not an educated individual in terms of formal education, but common sense tells me that, like a reservation, it knows no boundaries. And it's going to move with the tide somewhere. And it's going to have impacts. And this is just one example of one thing that's going to come with this terminal. It's going to come into Boundary Bay. It's going to come and affect things that mean more than monetary value to us. Existence is more important. The fact that this relationship we've been brought up with, that we're second or third to everything that is, so we're less than, so we have to live as humans with a relationship knowing that we can't live without. And they belong more so than us. So there's a lot that is already taking place from like Tawasin and the vessel traffic and the southern residents, because we're directly connected in spirit. And I know that I don't know how to exactly put all of this into English words, totally. But there's a strong connection to everything that is for us as a people. And so Roberts Bank is, the coal port was much more than just, 452 ships and 52 million tons of coal piled on top of our ancestors. It's more than that. There's a lot that comes along with these giant projects that what's painted to you and the narrative that is created is that it's good jobs, it's good trade, we need ports, we need this, we need that. But for us, common sense says at the expense of what? And when is enough enough? When are we going to be satisfied? Why do we lust for so much development and, this stuff that is detrimental to our culture, environment, way of life? Yeah. That answer?
More questions? I have a question for John in terms of the Haida case that you referenced being a very formative one. With my understanding is that in that case, it's clear that there is reference to ongoing claims by the Haida for Haida Gwaii and the complexity of those of that negotiation. And last summer, I believe, Premier Trudeau visited Haida Gwaii to sign an actual, I don't know if it was a settlement claim or what the correct wording would be, but I'm wondering if that that step changes in any way the sort of substance of that already declared obligation for consultation. If that has changed anything on the ground.
That's a good question. I think it certainly changed things on the ground for the Haida. So what it was is they filed their Aboriginal title claim to the entirety of the islands prior to the Haida case in 2004. So that was kind of the basis. That was the grounding was. So, there's lots of activity going on, particularly in forestry, and, BC's making all of these decisions. The Haida's like, hey, by the time we have our claim heard and we win, there's not going to be any forest left. And that got some traction with the court. The Weyerhaeuser and BC was like, well, you can just go get an injunction. It's like, well, we can't get an injunction for 10 years. Like it's not going to happen. So in their case, I think that they're in a unique position because Haida Gwaii, we can go to our map here. Haida Gwaii is in the middle of the Pacific Ocean. Haida Gwaii, like the Haida don't have to deal with issues of what we call shared territory or overlaps. Nobody came to attack the Haida. The Haida got bored and they came and attacked everybody else. And I apologize to Lummi for some of the history there as a Haida person. And also, there's not a lot of fee simple titles there, right? There's not a lot of people who live there who have titles that might be at risk with a declaration of Aboriginal titles. So Canada and BC came together with the Council of the Haida Nation and said, okay, well, let's agree that you have Aboriginal title here. However, the elements of Aboriginal title that come out of the court cases really don't apply. Like things like you have a right to determine how the land's going to be used. You have jurisdiction over those lands, including taxation authority, for example. Like all of the things that we would think a government, say like a state government or provincial government might have. That's what you get with Aboriginal title is it's your land. You can do with it as you see fit. So, it looks good on paper. But in a lot of ways, it's more of a political agreement than a legal one. And maybe that's partly the solution because they still want to be able to, there still is a forest industry, even though it's on life support. And, we don't want to disturb the settlers in situations where they've invested, tens of thousands, hundreds of thousands of dollars. So it's a potential model that's out there, but I think once you get onto the mainland, you're going to have people fighting over, whose land is it? And that's also a function of colonialism, as I said. You got 200 plus bands now, The entire province is has been claimed. Not 2 times over, but I think 140% in terms of, you start having these overlaps either through treaty process or through court cases. So it's a tough one for the governments to figure out.
Thank you. Yes.
So I have a question. So what are the transboundary implications of a decision like this? What you are seeking is right of consultation.
Yeah.
So if it's granted to the Lummi in Canada, does it apply to the United States? And is there a way to enforce that kind of decision here in the US?
No. No, we need to pursue these claims in Canadian courts, and in terms of US, I think it's more political, sort of getting, for example, Army Corps of Engineers on board, in terms of reviewing these projects and pointing out deficiencies. But yeah, that's a hard border in that case. So yeah.
Hi, I was just wondering if the tribes have to pay for the attorney, or if the attorneys like yourself are doing it pro bono, or if because you are native yourself that you are helping your people. I just wondered how that was going, because I know a lot of tribes don't have a lot of financial means to pay for attorneys, and I just wondered how that process goes. Thank you.
I'm not familiar with that term, pro bono. Fortunately, Lummi has resources that it can draw upon, unlike a lot of tribes. I've said this before. I stayed at the Silver Reef last night, so I donated my fees back, I think. Anyway, so it's kind of like it's a bit of a circle there when I do come down. But yeah, it's definitely a challenge. And with the First Nations that I work with in Canada as well, right, is you've got all of these priorities that are drawing upon your resources, and you're up against, and especially when you're up against government, you're up against, entities that have limitless resources, and it seems limitless number of lawyers that they can draw upon, not just internally, but even, government of BC in terms of Lummi. They've gone out and hired, the big downtown Vancouver law firm to try and defeat us. So yeah, I get paid in US dollars, which is also really nice with the exchange rate.
Are there other questions?
Well, don't let that guy talk.
I thank you all for being here. My name is Dana Wilson. My ancestral name is Claxton. But as Jay referred to earlier, like the Lummi that paddled to Mukilteo to sign the treaty in 1855, 14 of the 16 signers were reef net captains. So that's the reason that Lummis and those skippers went to sign that treaty is to preserve a way of life as fishermen, and the way of life that they knew. That's all they knew. That's just a way of life that they knew. So that's all we're doing today, is in these fights, is trying to preserve a way of life that we know as a fishing community. And in that fishing community, I think it helps all of us here in Whatcom County and everywhere else to preserve a way of life that I think our way of life, as we've been living since recorded time, is a pretty good lifestyle. So we're just trying to, that's what we're trying to preserve, is that lifestyle, and that so that our children and our great grandchildren and will have that way of life. So I would just want to again thank you all for being here and listening to our story.
Thank you. Do we have time for one more question, perhaps? We're getting close to the end of our time. Okay, let's take an online question. So we have a question from an online participant. What can attendees do to engage in a remedy? And we had an earlier question as well, also online. What can we, all of us, do to help advocate for Lummi Nation in this effort?
Do you want to take that one?
What can we all do to advocate for Lummi Nation in general? In this situation?
In this situation.
Yeah. I think it's really important for all of us to know that a treaty isn't an Indian thing. It's a newcomer's thing. It's your treaty. It's not a damn Indian thing that gets in the way of progress and development. It's a promise between two sovereigns that created the beginning of this place that we all call home. It's not an Indian thing. It's Article 6 of the United States Constitution states it's the supreme law of your land, your country. So it's not an Indian thing. So when the Army Corps has to allow, or through their process and because of past behavior and a culture created within the Department of Army or federal government, to put the 106 process and treaty rights at the end of a process where Warren Buffett and all of those giant money companies are funding a development project, it's hard for us to go up against them, like in the Cherry Point Coalport case, for example. Goldman Sachs. I had to do things like sneak into the Salt, Utah annual shareholders meeting, strategically not identifying myself, but getting a proxy from a church to let them know that they're developing on a cemetery. But it's yours. I think it's, once we shift the thought process that we have ingrained in us through public school from kindergarten to grade 12 of what your perception of an Indian is, maybe a stone-faced, never smiles, savage, that's not, it's so far from the truth. We're partners. We're in a marriage together under Article 6 of the Constitution. It's yours just as much as it's mine. And then we have to ask ourselves, what does honor really mean? The English word honor. What does it mean? When something so significant took place for, I'm just speaking for myself and my people in 1855, something so dramatic and drastic and significant took place where my world since the beginning of time is turned completely upside down. And what is beautiful to you is a completely different world that we don't want to assimilate. We don't want to colonize. We want to hold on to a relationship-based life for as long as we can. We want our marriage with you to have a love for everything that is just as much as it does us. And it's not a green tree hugging thing. It's relationship, a giver of life. So how do we come together and do that together? That's how I would answer that question is, it's your treaty. It's not an Indian thing. We didn't go meet with president and say, hey, get Stevens over here and we're going to negotiate this thing called a treaty and you're going to sign this legal document. No, it's a United States immigrant thing to us. And we entered into that. So what does honor mean? What is 23% of 24 maybe now? A percent of our guaranteed reserved right, not a privilege under the treaty. What we do to protect sacred sites, exercise fishing rights is not a privilege. through the feds, through the state, through the county, through the cities. It's a reserved right in that agreement in 1855. When you go buy a license to go fish in Bellingham Bay and the San Juan Islands and go do stuff in the San Juan Islands and catch a crab and catch a prawn, you're exercising a privilege under the state of Washington, who, because of Bolt, co-manages with Lummi. 50% go to you, 50% go to us. It's a right. Through the state, it's a privilege. Citizens, when you buy a license to fish. So that's what I would share is it's ours, it's yours, your treaty. So how do we honor it together?
Okay, please join me in thanking our speakers today. We're grateful and honored to have you with us today, and we look forward to more conversations. Thank you. Thank you.